Librarians, including music librarians, often have to deal with copyright issues. We can only scratch the surface of some of the issues that might arise here, but we'll introduce some of the most important concepts so you know where to look next. Of course, none of what follows is legal advice. This is just an introduction to some basic concepts around copyright for music librarians. Copyright holders have 6 basic rights that can impact how music can be used in libraries. They have the right to control the reproduction of their music, the creation of derivative works such as arrangements, covers, or recordings. They can control how it's distributed, performed, or displayed in public, and how it's broadcast. These all impact what libraries can do with scores and recordings we hold, and what our patrons can do with what we provide to them. For example, a patron cannot legally check out a CD and then play it at a public event, or even rip a copy of a CD they check out to their personal computer. The library cannot digitize their whole LP collection, put it on a public website, which would mean essentially reproducing and broadcasting the music without permission. One important thing to realize in music is that you can have multiple copyright holders to deal with: the composer or songwriter, the editor, and the performers. Copyright should be taken seriously, and it can be a bit intimidating, but there are some details and exceptions in copyright law that allow libraries and patrons to make use of their collections. Everything we create and document is automatically copyrighted, but copyright doesn't last forever. When the term of copyright has ended, music and other materials go into the public domain, which makes them available to the public for essentially any use. No one has any right to control those 6 activities anymore. The second way we can pursue some of these activities is by getting permission from the copyright holder through licenses. These can be free open licenses, such as Creative Commons licenses, that state the degree of freedom you can take with a material and make it freely available. Or they can be paid licenses that grant specific limited permissions. So this can include something like a paid license from a publisher or clearinghouse that grants you the right to have a public performance of a work, or a license from a library vendor that includes permission to download a certain number of tracks and keep them. These permissions vary, and you're going to have to read the fine print in any particular situation to see what's allowed. All libraries rely on the exception known as the first sale doctrine. This exception says that once a purchaser buys an item, they can sell, lend, or dispose of that item without permission. That's what allows you to sell a video game on eBay or give your roommate last year's textbook. That item is yours to do with as you like, but you can't make and sell copies of it or charge a bunch of people a fee to come watch your DVD. This doctrine is really important in letting libraries lend materials they've purchased. Finally, fair use doctrine is an exception that allows certain kinds of use depending on a variety of factors that have to be weighed in each individual case. Fair use is especially important in academic settings. I want to focus a bit on public domain and fair use, as they're a bit messy, especially with regard to music. Items come into the public domain when their copyright term ends, but the length of the copyright term isn't always clear. The basic guidelines are that intellectual property enters the public domain 70 years after the death of the last creator, 95 years after the publication of corporate works, or 120 years for unpublished works where the creator is unknown. Except because of when and where different laws are passed, there are variations based on the original date of copyright, whether notice of copyright was printed and renewed, and the location of publication. Sound recordings were not eligible for copyright until 1972. Until then, only the underlying composition was under copyright. Now, compositions and recordings are copyrighted separately, and the recording is considered a derivative work. Compositions are treated more or less like text. There's still a lot of variation, in part because notice and renewal of copyright was required for many years. Then just notice but not renewal, and now notice is not required at all. Everything is under copyright. For earlier works, look for the copyright C in a circle to find notice of copyright. Sound recordings are even messier than text, because when they entered copyright, rights were retroactively given to a number of works. Music recorded before 1923 will enter the public domain in 2022, 50 years after sound recordings were given copyrightable status. Works from 1923 to 1956 will then begin to rotate into the public domain 100 years or 110 years after their creation. However, there's a small window of materials published from 1972 to 1978 that has shorter terms, when notice of publication was required. Later materials are given similar terms to other kinds of works. Because a lot of what your patrons will want to use is still under copyright, it's important to know what they are allowed to do with it and in what circumstances. The fair use doctrine allows for certain kinds of use without permission from the copyright holders, as long as you obtain the material legally, including through the library. The difficulty of fair use is that there's no hard and fast rules, only a set of factors to be taken into account when deciding if a use is allowable, so it's hard to know for sure unless a court is called in to decide. When considering if something is likely to be challenged, you have to weigh these 4 criteria. The purpose and character of the work. Nonprofit educational use weighs heavily in favor of fair use, as does transformative use of material, whether that means creating a parody or using entertainment materials as the basis for scholarly study. The creativity of the original will also be taken into account. The more original and creative the material, the more careful you need to be in reusing it. In terms of the amount, using smaller excerpts is helpful, but there's no magic number of pages or percentage. The amount needs to be weighed with all the other issues, including whether the amount is suited to the use. You should only use the amount of material that is needed for your purpose. One very important factor in the likelihood of whether a copyright holder is likely to challenge you is the effect on sales or market for the original. If your use is educational, transformative, and doesn't significantly affect the market, it will probably be protected, even if the work is creative and used in whole. For example, a faculty member using an entire film or musical recording as the basis for class discussion is likely to be allowed because they're using the work intended for entertainment transformatively as educational content, and students would be unlikely to purchase the materials themselves. On the other hand, photocopying and posting a music theory workbook is not likely protected, even though it may not be creative material in the same way as an album, because it's being used for its original purpose and provided for free to the main audience the workbook would otherwise be marketed to. It is the responsibility of the patron to be sure that they don't violate copyright. But you may be asked to weigh in on a use, or they may ask you to do something like post material for them, so it's good to know what the potential concerns are, although we can never offer legal advice. While librarians will differ on their perspectives, my personal philosophy is that copyright terms are unnecessarily long and restrictive, and it's my role as a librarian to facilitate access and information, not prevent it. So I tend to err on the side of pushing fair use in the interest of my patrons over the interests of the recording industry or publishers, but without encouraging abuse.